Hello, everyone. Good afternoon, and welcome to this week's Business in 2024 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager with Bond. I'd like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and our panelists will do their best to answer those as time allows. Once today's webinar has ended, we would appreciate you taking a moment to complete our survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Kristen Smith.
Thanks, Kathy. Good afternoon, everyone. Good to be back this Tuesday. So before we get started with the agenda, just another plug for our workplace conference that we host throughout the state. We were in Corning last week, and by all accounts, it was a great informative day. Next week, we will be in Albany and Buffalo. So if you haven't signed up yet, please go ahead and do that as soon as possible. And then we'll be in those other cities listed following that. So hope to see many of you in person at these events. Next, I want to go over our agenda. So 3 speakers today, and we have a bit of a theme. These are all developments that have been happening on the federal level. I think we've been focusing a bit on state law quite a bit lately because we've been talking about the budget and things like that. And we'll get back to New York State, but today this is a fully federal agenda. A lot of developments lately. First, we're going to have Natalie Vogel out of our Albany office talking about some new EEOC guidance. And then we have an interesting new Supreme Court case that touches on employment discrimination. And we'll have Nick Jacobson from our Rochester office discussing that. And then finally, the NLRB never disappoints. Of course, I'm being facetious. And they are continuing an incredibly aggressive agenda. And Tom Miron from here, our Syracuse office, has an update on that. So why don't we get started with Natalie out in Albany, and she's going to tell us about this new EEOC guidance released just last week. Thanks, Natalie, for being here.
Thank you, Kristen. Happy to be here.
Are you set? Go right ahead.
Thank you.
Yep.
All right. So the EEOC released new harassment guidance on Monday of last week, April 29th, 2024, that took effect immediately. This guidance supersedes previous EEOC guidance on harassment, but notably, they have not published any guidance since 1999, so this was a long time coming. Just as a note, as I go through everything I touch upon today, nothing is legally binding with this guidance, but it serves as a resource for employers and employees when investigating and litigating claims for workplace harassment. And as this is EEOC guidance, they will be using it when investigating their own claims brought to the agency. Next slide, please. The guidance has 3 overall prongs, which are not new to anybody who deals with harassment issues, but they are 1, covered bases and causation. So this prong focuses on whether the conduct was based on an individual's legally protected characteristic. 2, harassment resulting in discrimination with respect to a term, condition, or privilege of employment. So for workplace harassment to be unlawful, it must affect some sort of term or condition within an employee's employment. And then 3, liability, and they differentiated between different ways an employer can be liable based on a hostile work environment claim, and that depends on the status of the harasser. Just for the sake of time, I'm not going to really be touching upon the liability aspect of the guidance, but the other 2 prongs and some recent developments with the guidance. Next slide, please. So just as a reminder, the EEOC enforces Title VII, and these are the Title VII protected classes: race, color, religion, sex, including sexual orientation, gender identity, pregnancy, childbirth or related medical conditions, national origin, disability, age, and genetic information. Just as a reminder, employers should be aware of their state and local laws that extend these protected classes to their own state discrimination laws. For example, New York City recently added height and weight as protected classes, and New York has a variety of other protected classes, but for the purposes of the EEOC guidance, they only touch upon Title VII protected classes. Next slide, please. So for harassment to be unlawful, it must be with respect to a term, condition, or privilege of employment. So the guidance touches on two aspects of harassment. One, quid pro quo, what's the guidance defines as an explicit change to the terms or conditions of employment that is linked to harassment based on a protected characteristic. The classic example of quid pro quo harassment is firing an employee because they rejected sexual advancements. And then the guidance also addresses hostile work environment claims. So that's conduct that constructively changes the terms or conditions of employment. So again, this is addressing the federal standard, which states a hostile work environment exists when harassment is so severe or pervasive that a reasonable person in the employee's position would find the situation to be abusive. And as a separate note to that, the guidance also touches on that the hostile work environment claim has to be both objectively and subjectively hostile. So the complainant must find the situation hostile, and then here a reasonable person must also. And I just wanted to make a note that in New York, the standard for a hostile work environment is that harassing conduct must rise above the threshold of petty slights or trivial inconveniences. So I just want to mention that because if you're reviewing the guidance, looking at it, examples, I just want to note that conduct that may not rise to the level of unlawful harassment under Title VII, which the guidance in the EEOC covers, it may still be unlawful under New York law. So that's just a consideration for employers to think about when reviewing the guidance. Next slide, please. So a lot of the guidance touches on classic principles, but since the EOC has not published any guidance since 1999, there have been a lot of developments in the law since then. So more recently, I'm going to touch upon these examples that are recent in developing areas in workplace harassment. So for example, in 2020, the Supreme Court case Boxton v. Clayton County extended employment discrimination under Title VII to include discrimination based on sexual orientation or gender identity, and that is included in the new EEOC guidance. And then, as we all know, there has been a wave of new laws protecting employees with pregnancy, childbirth, and child-related conditions, such as the Pregnant Workers Fairness Act and the Providing Urgent Maternal Protections for Nursing Mothers pump. Guidance also touches upon those. And then, as everybody knows, since COVID, there's been an uptick in remote work. So the guidance also addresses a variety of instances of harassment related to remote work. Next slide, please. So first, I'm going to be touching upon the examples the EEOC provides with harassment based on sexual orientation and gender identity. So these are all examples right out of the guidance that the EEOC considers harassment. So first, outing or disclosure of an individual's sexual orientation or gender identity without permission. Harassing conduct because an individual does not present in a manner that would stereotypically be associated with that person's sex. Misgendering or repeated and intentional use of a name or pronoun inconsistent with an individual's known gender identity, and denial of access to a bathroom or other sex-segregated facility consistent with the individual's gender identity. And again, these are examples right out of the guidance that the EEOC will likely consider harassment if done in the workplace. Next slide, please. So then the EEOC also addressed pregnancy, childbirth, or related medical conditions. So they stated that workplace harassment can arise from topics such as change in an employee's physical appearance due to pregnancy, lactation, morning sickness, using or not using contraception, or deciding to have or not have an abortion. So if these topics are brought up to an individual in a harassing manner, the EEOC will likely find harassment on that. So on the next slide, I provided an example as when these topics when discussing these topics can result in workplace harassment. So Kathy, if you could please go to the next slide. So I included example number 13 in the EEOC guidance here. Notably, was, I think, around 77 examples. So this is just one example that I pulled today to just kind of see the application of harassment based on a pregnancy-related condition. So in this example, an employee is experiencing morning sickness. So her employer accommodates the limitation with a hybrid telework schedule. Colleagues complain that pregnant women always get special perks and privileges. They accuse the pregnant worker of getting pregnant just so she can kick back, relax at home on the couch, and collect a paycheck. And then when the pregnant employee asks to be considered for a new high-end client, a coworker on a call states, if the employee is so sick that she cannot come into the office, how can she be well enough to work on such an important account? So this is an example where the EEOC found harassment based on a pregnancy-related condition, and that pregnancy-related condition is morning sickness. Next slide, please. And so then remote work is another up and coming topic. So the EEOC's guidance emphasized that harassment may occur in a context outside of an employee's regular workplace. So while there are traditional functions such as happy hours or other work sponsored events, this also extends to remote work. So this could be harassment through email, instant messaging, video conferencing, social media accounts, and other equivalent services. And on the next slide, I'll go through some examples of when there can be harassing conduct through these networks. So again, these are all examples straight out of the guidance. First, sexist comments made during a video meeting can be a form of harassment. Ageist or ableist comments typed in a group chat. Racist imagery that is visible in an employee's workspace while the employee participates in a video meeting, or sexual comments made during a video meeting about a bed being near an employee's video image. So again, the EEOC is really emphasizing that harassment does not need to take place physically in the workplace, but can extend to all these different avenues. Next slide, please. So just as a conclusion to all of this, the guidance is very long. And as I said, it contains 77 or so examples. So I just wanted to touch on, some of the more recent developments in the law. So in addition to the guidance, the EEOC also posted a summary of the guidance's key provisions, facts for employees, harassment at work, and a fact sheet for small businesses. So those are very good resources to consider when dealing with harassment. And we also will be posting a blog post article on this topic shortly, hopefully within the next day or two. So keep an eye out for that, and then reach out with any questions to me or another member of the Labor and Employment Department with any questions on the harassment guidance from the EEOC.
Thanks, Natalie. Yeah, definitely recommend checking out this guidance. It's worth the read. In my opinion, when it's always interesting when the agency gives actual factual examples. And of course, really important note that Natalie made is that, something that would not necessarily be harassment under the federal guidelines may be under New York State. So just keep that in mind, that there are different standards. But of course, if the EEOC is saying it would violate federal law, then there's no question that it also violates New York State law. So really interesting. We don't get new guidance from the EEOC very often. A lot of the guidance on the EEOC website is a little dated. So interesting stuff. Thank you so much, Natalie, for that. And let's move on to the next topic. This is a Supreme Court case that came out pretty recently, Muldrow versus City of St. Louis. So I asked Nick to be here to give us an overview. It's on a bit of a narrow issue, I would say, but an important one, a really important one, I think. So Nick, tell us about the case.
Yeah, thanks, Kristen. And it is on a somewhat narrow issue, but I think it could have somewhat broader implications as well, which we'll definitely get into. Next slide, please, Kathy. So the case that Kristen mentioned is Muldrow versus City of St. Louis, and involved a change in the standard for what constitutes an adverse action with respect to a transfer of employment. So the case concerns Sergeant Jatanya Muldrow, who worked in the intelligence division of the St. Louis Police Department. She was characterized by the intelligence division's outgoing commander as a workhorse and the one sergeant that he could count on. In her role in the intelligence division, she investigated public corruption and human trafficking. She oversaw the gang and gun crimes units. She was deputized as an FBI task force officer, which allowed her to pursue investigations outside of St. Louis. And she also had an unmarked take-home vehicle. Next slide, please. So a new intelligence commander came in and requested that Sergeant Muldrow be transferred, and he then replaced her with a male colleague. Prior to the transfer, he referred to Sergeant Muldrow as Mrs. rather than Sergeant, and he later testified that he felt the other employee, who was again male, seemed a better fit for the position's very dangerous work. Next slide, please. So in Sergeant Muldrow's new position, she was in the uniform division. She supervised the day-to-day activities of neighborhood patrol officers. So her duties were kind of, significantly different, I would say, from what she was doing in the intelligence division, where she served as more of a detective rather than a uniformed police officer. In the uniformed role, she lost her FBI status and her take-home vehicle. She no longer worked with high-ranking members of the department on important investigations. And also importantly, she worked in a regular schedule that often included weekends. Next slide, please. So Sergeant Muldrow brought an action under Title VII alleging that she was unlawfully transferred due to her sex. The district court, on a motion for summary judgment, found that the transfer did not constitute an adverse employment action and granted the city of St. Louis summary judgment dismissing her claim. In reaching that decision, the district court applied the predominating standard at the time, which was that the transfer must constitute a significant change that creates a material disadvantage to be actionable. Almost all courts, except for the DC Circuit, followed this standard at the time. And that includes, for those of us in New York, the Second Circuit, although, as we'll touch on later, the Second Circuit, I think, did apply the standard. Even though it was the same standard, I do think it was applied a lot more liberally in the Second Circuit. Next slide, please. So the district court, again, applying that significant change, material disadvantage standard, found that the transfer of Sergeant Muldrow wasn't actionable because there was no change in her salary or rank. The loss of her FBI credentials did not harm her career prospects with the city of St. Louis. She continued to have supervisory responsibilities, even though she was in a different role. And the loss of the vehicle and schedule changes were not significant. Sergeant Muldrow then appealed that decision to the Eighth Circuit Court of Appeals. Next slide, please. So the Eighth Circuit also applied the standard then in effect, which was the significant change material disadvantage standard, and upheld the district court's decision. The Eighth Circuit echoed the district court's reasoning and found that Sergeant Muldrow had only demonstrated minor changes in her working conditions. Notably, the Eighth Circuit did not address the schedule changes or the loss of the vehicle because of procedural issues, which is going to become important later. Next slide, please. So the case then made its way to the Supreme Court to resolve the circuit split essentially between the DC Circuit and everybody else. And ultimately, the Supreme Court agreed with the DC Circuit and found that the significant change material disadvantage standard was improper. The court noted that Title VII prohibits discrimination with respect to the terms and conditions of employment. Involuntary transfers usually involve changes to the terms and conditions of employment, most often to the employee's detriment, hence why the transfers are not voluntary. The court went on to hold that applying an elevated standard for transfers requiring significant changes to terms and conditions of employment improperly added words to the statute. The new standard that the court settled on was that the transferee must demonstrate some harm respecting an identifiable term or condition of employment. So you can see where that standard is, pretty substantial departure from the significant change material disadvantage standard, at least in terms of language. Next slide, please. So the Supreme Court also did discuss application of the new test to Sergeant Muldrow's allegations, and it held that if those allegations were properly preserved and supported, that she had met the some harm to an identifiable term or condition standard with room to spare. The court noted that the new position was less prestigious and important, that her schedule became less regular and required weekend work, and also that she lost the take-home vehicle. So ultimately, what does this mean for Sergeant Muldrow? Well, we don't know at this point how things will shake out for Sergeant Muldrow. As the court noted, it held that she had met the standard if her allegations were properly preserved and supported. And as we mentioned earlier, the Eighth Circuit held that at least some of those allegations weren't properly preserved and supported. So ultimately, the Supreme Court did not issue a determination respective to whether or not Sergeant Muldrow's case would be reinstated, and it instead remanded the case to the Eighth Circuit to resolve the procedural disputes and issue a decision under the new standard. Next slide, please. So how does this affect employers moving forward? So transfers are much more likely to be found to constitute adverse actions. And when considering an employee, a transfer of an employee, it needs to be considered more like a termination because again, if it, under this new standard, a transfer is much more likely to constitute a change in the terms and conditions of an employee's employment. And all they have to do is show some harm with respect to those terms and conditions rather than a significant harm under the prior standard. Another thing to keep in mind is that this change would also logically affect decisions not to transfer an employee. So by denying an employee a transfer, that would arguably also be more likely to constitute an adverse action. Reading the court's decision, I could see where this new standard could also be applied to other types of actions, potentially even unfavorable assignment of shifts or job duties. I found it particularly notable that the Supreme Court focused on the loss of weekend work or the addition of weekend work as a result of the transfer as being evidence of an adverse action. So, I think we want to keep an eye out for whether this change bleeds into other types of actions that might be taken by employers. One thing to note, though, here in New York, at least, I don't think it's quite as significant of a change to our way of thinking as it might be in other circuits. Both Justices Thomas and Alito issued concurring opinions in which they essentially noted that they agreed with the court's ruling in principle, but that they felt it was essentially more a change in language than a change in how the test was being practically applied. And I think that's very true in the Second Circuit. This was an issue that came up fairly often, and while the Second Circuit did apply the same test, at least in terms of language, as the Eighth Circuit, I was very surprised reading this case that the Eighth Circuit didn't find that Sergeant Muldrow met the prior standard. Given the loss of the take-home vehicle, the loss of the FBI credentials, the significant change in job duties, and the scheduling changes, I would have thought, at least in the Second Circuit, that her case would have survived summary judgment, even under the prior standard. Also important to note, here in New York, under the human rights law, it was amended in 2019 and adopted a more liberal construction of the adverse action standard. So under state law, we would have ordinarily expected a transfer like Sergeant Muldrow's to likely rise to the level of an adverse action as well under state law, even if it didn't meet that threshold under federal law. So if employers, if you're out there dealing with considerations regarding transfers or even potentially changes to employees' job duties or shift assignments more generally, I'd encourage you to reach out to discuss whether this change in the law might impact your decision making.
Thanks, Nick.
All right, thanks, Krista.
Yeah. Particularly from our perspective as employment litigators, this just takes a tool out of our tool chest, right? It takes that argument away that I think we've all made so many times that, regardless of whether the decision was discriminatory, it wasn't adverse, it wasn't materially adverse. So
exactly,
kind of makes that argument harder to make for us. But just a good reminder, right? Because we think, I like how you said to look at it like a termination, right? Because I think you put a lot of effort in making sure that we're making big decisions like terminating someone, that we're going through the analysis, making sure there's no risk there. But this really gets down to those more day-to-day decisions that maybe aren't elevated up through the organization. So, food for thought about that, right? So thank you, Nick. And so we're going to go to our third presenter here, staying out of Washington, D.C., I suppose. And going to talk about the NLRB with Tom Iran. So Tom, thanks for being here.
Thanks, Kristen. Good afternoon, everyone. It's always a pleasure to present to this group, and I'm actually looking forward to the workplace program later this month in Syracuse. We do these presentations, and I know there's a large audience, but there's no interaction. And we very much welcome the opportunity to meet you face to face, and hoping that you'll take the time to join one of our programs this month or June across the state. So we get to put a name to a face and interact in a great environment. So looking forward to that. I'm back to talk more about NLRB issues and really another chapter in the aggressive agenda of the current general counsel at the NLRB, Jennifer Abrazo. And as I look at this, take a step back 10,000 feet, the administration was not able to change the law, to change the statute, to get an amendment to the National Labor Relations Act passed. And neither this administration or prior Democratic administrations have been able to do that. So instead, they have this strong concerted effort to change the law within the same structure. And the general counsel is leading the charge here. So Kathy, if you could go to the next slide, please. And we've seen this before, right? The general counsel has now issued a new memo talking about remedies. And these memos are important because they give us insight into what direction she is giving to the regional offices who are responsible for investigating charges and deciding whether to pursue them to complaint and hearing, and obviously controlling settlement discussions. And also gives us information on the arguments that the general counsel will put to the board on ways in which to modify the law, and in this case, expand the law. If I could have the next slide, please. Several years ago, the general counsel started this initiative with two memos talking about her objective of expanding remedies. She used the phrase a full full panoply of remedies for the various violations. And the board paid attention. Next slide. In the Thrive case, which is now 18 months old, the board did expand the remedies that it would pursue in the case of an individual who had been discriminated or discharged in violation of the law, allowing the region to pursue not only back pay, but other foreseeable costs or harms that the individual incurred as a result of the alleged or proven unlawful conduct. So now we have the next step in the process. This is the new memo that came out a month ago. Kathy, that's on the next slide. And it's the General Counsel's efforts to obtain full remedies for victims of unlawful conduct in the context of an unlawful work rule or policy or an unlawful contract term. All right, so we're expanding the remedies that the board will pursue or the region will pursue when there's a challenge to an employer's work rule or work policy. And we need to pause there before we understand the implications of this new memo to remind ourselves of where we are in terms of the board's analysis of work rules and policies. And that is the Stericycle case. Kathy, if you could go to the next slide. You will well remember that for about the last 20 to 25 years, the board has been has had a target on evaluating employer work rules, policies, and the whole range of policies, communication policies, social media, confidentiality, investigations, workplace conduct, workplace codes of professional behavior, etc. Analyzing those on their face for whether or not they interfere with the employee's Section 7 rights. And this is in the context both of unionized employers and non-unionized employers, right? Do you have a policy on the books that the labor board views as interfering or coercing employees in the exercise of their Section 7 rights, the rights to join and form a union or to engage in other concerted protected activity? And the board's analysis of this has bounced back and forth between the Democratic administration and the Republican administration. So now we're faced with the Stericycle case that says that a rule will be presumptively unlawful if the General Counsel can show that it has a reasonable tendency to chill employees' exercise of their Section 7 rights. And in examining the rule, we look at it from the perspective of the employee, the reasonable employee, but the board puts a little extra spin on that reasonable person, right? It's a reasonable employee who is, quote, economically dependent on the employer and who is, quote, contemplating exercising their Section 7 rights. And it only has to be one of a possible reasonable interpretation, right? There could be other reasonable interpretations of the rule that would be viewed as non-coercive or non-interfering, but the General Counsel makes out her claim if they can assert one such interpretation. And I'm going to give you a couple examples in a minute of how this has been playing out. So that's the step one in the Stericycle case. And then step two is, and Kathy, if you go to the next slide, the employer can rebut that presumption if it advances a legitimate business interest, which is often the case, but also the employer must show that that interest can't be achieved without with a more narrowly tailored rule. So what we've been saying since Stericycle came out 18 months ago is it's critically important for employers to draft their rules, review their rules, their policies, with an eye toward this standard and being very specific on articulating the business justification for the rule. Because again, this can be a standalone challenge to a rule on its face, right? A simple Section 8A1 charge that says the employer is maintaining a rule, for example, a rule on confidentiality that interferes with employees' exercise of Section 7 rights. It doesn't have to show, it doesn't have to be an allegation that that rule has been applied to an employee who is attempting to exercise Section 7 rights. It can be a challenge on the face of the rule. So, since the Stericycle case, I can point to two cases that are working their way through the board process. These are administrative law judge decisions, so they're interim decisions. They aren't final yet, but they give us some flavor of what Stericycle means. And Kathy, if you could go to the next slide. This is a rule that dealt with confidential information, and it prohibited the photographing or recording through any means of the company's operations, systems, presentations, communications, voicemails, personnel, or meetings. Pretty standard prohibition against recording or photographing on company property. And the ALJ found that this was presumptively unlawful under Stericycle and gave two examples, hypothetical examples of how this could be viewed as interfering with an employee's exercise of their Section 7 rights. So if an employee would reasonably understand the rule to prohibit them from taking a picture of hazardous work conditions or unsafe equipment, it would also prohibit the employee from recording a communication which would document inconsistent application of the employer's rules. Because you can postulate these scenarios, the rule on its face is presumptively unlawful, and the employer then has the burden of showing that it had a business justification for this rule, or be found in violation of Section 81. Next slide, Kathy. So the second case, again, this is a case that's winding its way through the board process. The employer had a policy to protect confidential information. And the policy stated that employees are expected to protect the assets of the corporation and use them efficiently. Those assets include tangible and intangible assets such as confidential information. Examples of confidential information include non-public information about the corporation's plans, earnings, financial forecasts, business forecasts, discoveries, competitive bids, and technologies. And if we stop there and you ask me to describe what type of confidential information this rule was intended to apply to, I would tell you it is confidential proprietary business information about the financial prospects of the firm and the internal competitive information that it has, which sets it apart from its competitors in the marketplace. But this rule also says company plans, and the ALJ concluded that you could reasonably read that as including employee benefit plans. And so you could reasonably, according to the ALJ, not according to Tom Era, according to the ALJ, you could reasonably read this rule as prohibiting an employee from disclosing employee benefit plans. And in that regard, it would be a disclosure that inhibited the employee from engaging in protected Section 7 activity.
Hey, Tom,
Yes, Kristen.
something happened to your audio. It's like you're in an echo chamber. I don't know if there's any setting there. I know you're getting towards the end here, but I just thought I'd mention that. I don't know if there's something you can click.
Okay.
It was fine when you
Yeah.
started, and then give that a,
I haven't changed the thing.
it's still echoey. We can get to the end. I just thought if there was an easy fix, we'd have you fix it before you finish, but don't know what's
Okay.
going on. I'll go back off and let you finish.
Okay. So you can see the nature of how the court or the ALJ read this rule and the significance of a well-crafted, tightly written policy. So Kathy, if you go to the next slide. Just worth mentioning, we're talking about the rules as written and evaluated on their face. Of course, if the rule is promulgated in response to union activity, it could be treated as unlawful, or if it's been applied in a discriminatory fashion. In other words, applied to someone who is engaged in considered protected activity, but not applied to someone who is engaged in similar situated activity unrelated to Section 7. The rule could also be challenged. Go ahead, Kathy, next one. So we get back to the directive from the General Counsel that was issued last month to seek full make-whole remedies. The current standard, the practice that has been in existence for some period of time, was if the rule was found to be unlawful, the rule would be expunged. And if there was any discipline imposed on the charging party for violating the rule, that also would be expunged. And obviously, if the individual was suspended or terminated, they would be reinstated and entitled to back pay. So here's the jump. Under the new standard that the General Counsel has put forward, the regions are going to not only expunge the rule, but also look at all discipline, all applications of the rule in the statutory time period, 6 months. So go back 6 months and look for any applications of the rule that could impact Section 7 activity, and not just where it was clearly Section 7 activity, but also any employee conduct that touches the concerns animating Section 7. And seek to expunge and correct all of that discipline as well. So it's essentially creating a class action scenario for individuals who have not filed a charge. And this is the direction that is being given to the regions. So if we're talking about trying to settle a case, we can anticipate that the regional officer will insist upon a review of all discipline over the last 6 months under the challenge rule. And if the case goes to litigation and ultimately is found that the rule is unlawful, as part of the compliance process, we can anticipate that the board will require a review of all of the activities enforcing the rule, and remedying those, even those unrelated to the individual or the circumstance that gave rise to the charge. So a dramatically expansion of the remedy in a circumstance that was already fraught with concern, given the Stericycle decision. We call this to your attention because it simply creates a greater pressure on all of us to monitor, update, and carefully draft our work rules and employment policies to take our best steps to control the risks associated with this aggressive agenda from the General Counsel. Thanks, Kristen.
Thanks, Tom. I want to apologize to everyone. The audio did get a little, we could hear you, could understand you. It just had to listen a little harder. And in fact, it sounded a little bit like you're like the voice in a haunted house, very spooky. So I think that's actually really appropriate for this topic, trying to scare us all. So yeah, I mean, right. The takeaway here is you got to look at those policies, because this is such an incredible remedy to go back 6 months and look at all the discipline. I mean, it's just, I can't think of any other word except that's incredible, right? Hard to believe. So appreciate you, Tom, giving us that update. Everybody go back now and dust off the handbooks, make sure that not only are they, complying with all those New York State laws we talk about all the time, but is there anything remotely possible that they could be read, as infringing on Section 7 rights? And as always, we're always happy to help you out with that kind of work. Thanks for being here today. Here are our presenters' contact emails in case you want to follow up. And we'll take a look at that audio, and we will make sure we're good on that next week. And Gabe will be here with you next week. I'll see you in 2 weeks. Thank you, everyone.